This meeting is being recorded, and with permission of the chair, I will start roll call. Mary Baldwin.
Present.
John Lund.
Present.
Reem Alos, no longer with us. Judge Wendy Chang. Bridget Grammy.
Yes, here.
Dan Grunfeld.
Yes.
Eric Helland.
Here.
Jim Sandman.
Here.
Thank you.
Great. Well, hi, everybody. It feels like a long time since we were all together, and it really wasn't. That just shows what's happening these days. Since our last meeting, we've tried to take some steps to really move this discussion forward in a hopefully a quantum leap kind of way. And to that end, Bridget and Grammy and Daniel Grunfeld took a deep dive into some of the issues, really the central issue that we're looking at right now, which is, the basic kind of governance structure and how the sandbox is to be, basically set up and administered in a sense. So they've done the memo that we circulated, and we thought it made sense today to have them walk us through their thoughts, because, again, and thank you to both of you for doing this. They really took a deep dive and thought hard about these things. And let's see what we can do to move this forward before our larger working group meeting. And we really would love people's thoughts. There are a lot of people here attending the meeting, and some of you are sort of silent observers, but we're really interested in everyone's thoughts, because we really want to move this forward, and we'd love to move on to our next assignment. But obviously in a careful way, because there's no point us coming up with some great model if in fact it's not workable for any number of reasons. So we really do, to the extent possible, want to encourage, everyone's input. So with that, Mimi, do we have to do anything else?
So before we get into the substantive stuff, first, I will call for public comment. If there's anybody from the public that is joined the meeting that would like to give public comment, please use the raise hand function, and I will call upon you, and you'll have 2 or 3 minutes to give your comment. It does not look like anyone's indicated by raising their hand. So the next item would be to approve the open session action summary from the February 9th meeting. If I could have a motion to approve it.
So moved.
Thank you, James. And a second?
Second.
Is that Eric? Okay. All right, I'll take the vote. Mary Baldwin.
Approve. Yeah, aye, whatever you want me to say.
John Lund.
I approve.
Judge Wendy Chang. Bridget Grammy.
Yes.
Dan Grunfeld.
Yes.
Eric Helland.
Yes.
Jim Sandman.
Yes.
Okay, thank you. Now we can move on.
Great. All right, thanks. So, and John, I don't know if you want to say anything before we turn it over to Bridget and Dan.
No, I maybe just highlight for everybody, we tried to put a little more substance into that memo you got in advance of the meeting to give you all a little bit of a chance to think through some of these issues. And I think really, hopefully Bridget and Dan will guide this discussion along those lines, but that may be a touchstone as we go through this as to some other elements of the question of high level structure and oversight that we need to work through.
I think that makes sense. Do you want us to go kind of walk you all through it, or did anyone want to comment before we do that?
I'll just comment and say that I thought it was a really great kind of summary of what I thought certainly the options, the more feasible options are that we've been discussing, and I thought it did a good job at pulling together the kind of pros and cons. So thanks for doing that.
A pleasure. Should we just go through it for the next X amount of minutes? So Bridget and I coordinated a little yesterday, just for efficiency's sake. we have some preliminary comments. We're going to go through the pros and cons of the options, which again, as indicated in the memo, are not presented in any particular order. I'll take the first two. Bridget will do the remaining three, and then I suggest we just open it up to questions, comments, observations, and next steps. Does that make sense?
Sounds great.
So in terms of just two very basic preliminary comments. One, as we were thinking this through, we came very early on to the conclusion that the governance in question here only applies for the life of the sandbox. We should not assume that whatever we learn will or will not have implications as to what may come down the line. But this is a big enough lift and complicated enough that we felt it important to sort of focus on the sandbox in terms of the governance issues moving forward. However, I think both Bridget and I agree that down the line, post-sandbox life, there undoubtedly, I would suspect, would be some lessons learned, not only in terms of the substance of what happens in the sandbox, but in terms of how the sandbox was governed. The second point is, and we're just putting a marker for future discussions, appearances of conflict of interest and conflicts themselves are going to be a critical issue, considering how public, how important we all, the task that we have taken on. So whatever model of governance we end up moving forward with, we wanted very early on to put this marker down as something that will need to be effectuated in whatever model gets chosen down the line. Bridget, before I take the first two, anything you want to add?
No, just that I know Jim had submitted some comments too, I saw in our materials, particularly as to the antitrust issue. And so I hope, anyway, feel free to jump in as we're talking about what we're proposing, the different sections. But as far as the conflict of interest, I think that does also play a role in the antitrust analysis as far as who, if there's active market participants who are in charge of the regulation. So the less we have people who are in the industry doing the decision making, I think that will help with the antitrust analysis, and we can get into that. I just wanted to acknowledge that Jim was making those comments.
Yeah, and those comments are attached to the materials that were circulated.
Yes.
Thank you, Jim. One last comment. We are, as we go through these 5 options and any 6th or 7th options that develop based on our discussions, these are non-exclusive, both pros and cons. We wanted to highlight the things that were critical and obvious. There are many things that both pro and con that may come up in our discussions as we move forward. So I think we're down from the 300-foot level to maybe the 30-foot level, but we're certainly not yet in the weeds for several reasons. One, we don't have enough information, and B, and more importantly, we don't yet have input from you and from others in terms of your thoughts and suggestions. So with that, option A.
Hey, Dan?
Yeah.
Before you jump into that, just for context, could you guys let us know how did you factor in the Adels memo that sort of already existed about this? Did you sort of start with a clean slate, or where did that fit into how you worked at it?
I'll speak for myself, and Bridget, why don't you jump in? I used it as a baseline in terms of a data point and some information. But it was not necessarily governing or controlling, partly based on the work that we have already done, and partly because the context of when this came up in Adels is very different than what we're trying to do now for the sandbox.
Okay, thanks.
Yeah, I agree with that. I think it was just kind of a starting point, but we were using that, and then also conversations that we had in this larger committee meeting last time, and as Dan said, things that have evolved since then, and So we didn't disregard, but we didn't just rely on it totally either.
Great, thank you.
So in terms of the choice A, independent nonprofit organization, the notion here is that a potentially an independent California 501c3 organization would be established, and there are any number of models within that rubric. Some of the advantages are that obviously as a nonprofit, the members and the board and the staff, when applicable, owe the fiduciary duty to that organization as opposed to anybody else while doing the work. That's both an advantage. It's mostly an advantage. It's also a bit of a disadvantage, but in terms of clarity of purpose and adhering to the core mission of what we're trying to accomplish, that would be a plus. Setting up in California 501c3, should we ultimately decide to go that route, is relatively straightforward. And importantly, while the application is pending, the work can be done. The substantive work can be done. Funding is a critical issue, as we've discussed before, and I'm sure we'll discuss at length today under any one of these models. Nonprofits are routinely in the business of applying for financial support, including, as you all know, from governmental sources. So being on the front lines, trying to raise money from whomever, the government, the foundations, and so on, is something that would be expected, would not cast into doubt the independence of the nonprofit, and on some level is a clean. As Jim pointed out in his comments, the question as to whether outside sources will fund this is a separate one. And at this point, I don't think we have enough information to offer an opinion one way or another. A member model in a nonprofit essentially permits some organizations or individuals to be, quote, members, and those individuals then in turn, organizations, are permitted to nominate board members and have other rights and obligations. So to the extent, by way of example, that we want either the State Bar or the Supreme Court or a combination of both or other entities to have a say moving forward during the operation of this nonprofit, that's something that could be set up. And another pro or advantage of this model is that it would be in a particularly advantageous platform to retain people with the needed expertise, as opposed to having individuals who have day jobs or other areas of expertise sort of shoehorned into doing the work. That, as we'll explain in a second, also plays to one of the cons. So the cons, again, there will be there's additional costs involved in both setting up and running a nonprofit. There are obligations that all nonprofits, and especially ones in California, have in terms of how they govern themselves, needing to be audited, needing to file tax returns, needing to comply with the bylaws that will come into effect as a matter of law and will need to be complied to. Also, after the Sandbox operation is over, the nonprofit will not automatically cease its role as an entity under law. It will need to be dissolved by application, and that involves some time after the work of the nonprofit has taken place. There is some constitutional issues. We alluded to this on one of our previous discussions in terms of how does, by way of example, the Supreme Court both provide the nonprofit with its independence and in its ability to do its fiduciary duties on the one hand, and on the other hand, maintain a measure of control over things that historically have been under its purview. there may be answers to this, but at this stage, we are not yet in a position to kick the tires in it as we will down the line as we move forward. And again, the transparency rulemaking procedures that I think all of us have agreed need to be in place because of the important nature of what we do and because we're required by law. And do not automatically come into being as a California nonprofit. They will need to be baked in, if you will, into the bylaws and need to be complied, but it's something that will need to be paid attention to. Jim also pointed out in his very thoughtful emails and comments that another con of this model is the whole notion of the qualified governmental immunity. It may or may not be something that we'll be able to walk around if we choose to go with this model, but it's only something that needs to be paid attention to, and not only for antitrust reasons. So that's the first option in play. Let me stop now, take a sip of water, and ask if there are any questions or comments before we go on to the next.
I have a question for you about this first model, and it comes, it's very much the same issue that Jim raised when he said that the 501, the disjoint between the idea of a private 501c3 exercising regulatory authority. Can you think of other examples in the United States where private nonprofits exercise regulatory authority that you think of as state authority?
No, but the answer is not because we simply have not done the research. There is, by the way, a precedent for the California Supreme Court getting involved in other nonprofits and having a bylaw roles. And so, full disclosure, I'm the former chair of the board of the California Supreme Court Historical Society. Under the rules of that organization, the Chief Justice becomes automatically the president, and board member, anybody who's a justice or former justice of the Supreme Court automatically gets to sit on the board if they so choose. Now, again, that's not a regulatory body, but all I'm pointing out is there is a history of this particular Supreme Court getting involved with a nonprofit in a way that's cooked into the bylaws.
Dan, if I may, Justice Souker, I don't know that this is probably not a straight parallel, but I just looked up on Wikipedia an entity called the International Conference of Building Officials. That I would probably predict is a nonprofit organization. It happens to be based in California, ironically, but what does it do? It establishes the code, the building code. And then what happens in every little town and county is they require people to comply with that code in order, to build a building in that place. So, I mean, they're not operating a review of plans like for the buildings, but they are, to that extent. I don't know if that's a delegation as much as it is a reference to that set of standards that are being established by a third party that then control what happens in their jurisdiction. So, I mean, I'm not saying that's entirely the same structure. In fact, I don't think it is. But you asked about analogies, and that just comes to mind.
Yeah. I was going to save this comment towards the end after we went through 05, but maybe now is the right time. And Bridget, please jump in because we've talked about this. There is a wealth of information and expertise out there from people who are not a member of this committee, but who have spent most of their entire professional careers working in this area, whether it be nonprofit, whether it be administrative law, whether it be governance, whether it be delegation by government bodies. It seems to me that at some point, maybe after we've narrowed down some of the options, getting those individuals to help us on a pro bono basis, which I think is very doable, would be very much advisable, because rather than guess or reinvent the wheel or educate ourselves, the people out there who I'm sure would be willing to help guide us in terms of our option. And that's something that I think in fairly short order, after we made some initial decisions, may be a course of action that we want to pursue. There's great expertise in around us. It would make sense from my perspective to call upon that expertise. Bridget, do you want to weigh in on this?
I was just going to say, I need to do some more digging, like Dan said. We talked about this a little bit, and one of the examples that I had brought up in our own conversations has to do with FINRA, and I honestly don't have enough information right now to share the way that works, but I do think that might be an analogy to what we're talking about, because I think it's a nonprofit, but it looks like, I think Congress authorizes it with a certain amount of regulatory authority to look at a specific area of like protecting investors. I don't want to speak any more than that because I really don't know the details, but that's an example of something that we might be able to look at more. I think maybe it was back in Addles, we were talking about the example of like vaccines actually, and how, you know, there are certain groups that look at that. That's about all the information I can tell you about it. But, you know, just like other groups that are maybe not government related, but that will look at the efficacy of vaccines or how they get approved and that kind of thing. And certain, you know, the FDA can rely on them to make that kind of decision. So these are examples we can look at if that's something that we as a group think is worth it.
Let me just ask one, I'm not sure I completely understand the pros of a nonprofit so much. But for example, the last point about the organization could retain or utilize the services of individuals who are expert in the subject areas. Wouldn't that be true of any of these bodies that had the authority to actually make hires?
Not necessarily. I mean, let's assume for the sake of argument that we want to focus, we think it important that the governance or the staff of the body that will oversee the sandbox is an expert in something like innovation. It is, or technological innovation. I wouldn't necessarily expect either the Supreme Court or the State Bar or you or me to be that expert if that's something we identify as somebody that we really want to be part and parcel of that. I mean, the advantage is that you actually get to put the people in there that you want from scratch, as opposed to sort of shoehorning it based on the skill set of the institutions that already exist.
Yeah, I get that point, but it seems to me that if we, you know, set up a structure that allows for the hiring of, you know, people to staff the organization, that it's, you know, that whichever form we use for that organization should be able to hire people with appropriate skills.
The general proposition, yes. In terms of appearances and actual room to maneuver, the argument is that a nonprofit, because it is truly independent and truly has its own fiduciary obligations, would have probably more rooms to maneuver. But again, there's a cost to that as well.
Okay, thanks.
The second model is having the governance done through the Office of the Supreme Court or the Judicial Council or somebody associated with the judicial branch. This is analogous, I think, to what is happening in Utah. And so the advantage is that the Supreme Court of any state, but I think especially true in California, brings to bear its own inherent gravitas and competence and the assumption of impartiality and independence. There's a reason why the California Supreme Court is generally regarded as the most important Supreme Court on the state level in this country. And the judicial branch, by its very nature, weighs conflicting interests and finds a way forward regularly, and that would be an advantage in the sandbox. There's some knowledge and expertise already in-house. Because the Supreme Court of the judicial branch has some authority already over attorneys, it will help establish consistent policies, and that would be a plus. The cons are, again, funding is unclear. The Supreme Court and the judicial branch doesn't have a whole bunch of money lying around. In fact, it's stained as it is. So how we fund this, should it come in under the auspices of the Supreme Court of the judicial branch, will become an important issue. And as discussed previously, including by our representatives, I can't remember if it was Neil or Greg, there's conflict issues that will need to be addressed and looked into to satisfy the concerns of the Supreme Court. The issue as to whether the judicial branch would be willing to move along the lines, assuming those things are resolved. It's too early to tell, but at some point they will need to be willing to take it on if this model is going to be a viable one. Let me start.
So on
Yeah.
that, you know, and obviously we'll discuss at the end all of these various issues, but you know, you and I know you're trying to walk through the pros and cons that you guys have set out in a little bit more detail, obviously in your memo. I guess one thing we will want to figure out, to the extent we can, you know, fairly early, I guess, in this process is, you know, whether the court has any appetite or capacity for considering this kind of model, because if not, then that's not something we want to spend a lot of time working on.
Agreed, and but I think, as always, the sort of a chicken and egg. We will probably need to have more information, both from the court and in terms of what is permitted and what viable models are, before the chief or other decision makers in the court can make that decision and get back to us.
I guess on this one, just a question kind of along the lines of what Justice Tucker asked about the independent model. Is there some precedent for this sort of a structure where some task force or other operation of the courts has been set up and operated under the auspices of the court, you know, at least on some temporary basis to accomplish some particular purpose?
Well, isn't Utah a version of this?
Yeah, I guess I was asking in the California experience.
I would say on a temporary basis, I'd have to go back and try to look. I know the Judicial Council does engage in several, a wide range of regulatory activities over the judicial branch. So there is a precedent there. I think under this option, funding probably is the paramount concern that the court might have, because funding can solve a lot of problems in terms of capacity to take on a new role, even on a temporary basis. I think that what's most important in terms of the chicken and egg issue is so that this group isn't held up wondering whether or not they're going down a dark alley and no hopes of success. What I have found is the most successful approach in task forces like this that are looking at a new way is to provide the court with well thought out options. So I don't think as we go through these, we should necessarily say that we have to land on one of these. There may be some that we can probably take off the table for fundamental reasons. I think with some of these options, when we get into concerns around separation of powers and perhaps placing this regulatory authority under the executive branch, I would caution the group that we may run into some immovable obstacles in that regard. And if the group still wants to pursue an option like that, and that we really do a lot of thinking, maybe get independent legal opinions to support the position. But then if that's the group's consensus, then to include that among the different options, because at the end of the day, the court is a deliberative body. We're used to oppositional briefing, and so the more options that we have that are well thought out and well supported, I think it makes the court's job easier in terms of evaluating where to go.
Greg, I take it, and please correct me if I'm wrong, that one of the messages of what you just said is that at this point, this option needs to be, the tires need to be kicked further, and we should continue to think about this as a potential option subject to further analysis and ultimately a decision by the Supreme Court. Is that correct?
Sure. I think that is a correct characterization of my position. The court hasn't really taken a position on anything that this group has decided, because we are still in the beginning of our decision-making process. But again, I think I don't want to be in a position to give any indication to send you down one path where I think we can actually, when the court hasn't had an opportunity to weigh in and give any sort of direction. So I think that the big concerns that I will bring up again is the separation of powers issue when we're talking about governance structure, and just making sure we think through that a bit. I had mentioned before, when we talk about funding sources, to the extent this entity is under the direct supervision of the court and we're receiving funding from private sources that may end up being parties before the court, I think that the justices will have some concerns about being forced to recuse themselves in certain situations, and not wanting to go to being found in that situation. So one of the things that we may have to explore under this option is to seek some legislative funding as well, and partnership in that way.
Greg, may I ask, you may not be the person to answer this, but does the court system have a grant making process? Is there somebody in the court system that works to try to find funds for projects the court wants to work on?
We make grants, usually through funding. So we have equal justice grants that are administered through the Judicial Council. I'd have to do some, I don't work for the Judicial Council, so I'd have to do a deep dive and figure out how exactly the different funds that are distributed for mostly access to justice initiatives or nonprofits, how that's handled. I know a little bit more about the IOLTA structure, but that's a bit different. But in terms of soliciting funding from private sources, the Judicial Council, I'm not sure they do engage in that, but I'd have to go back and look.
Yeah, Greg, this is Donna. I can add a little bit from my memory. Up until 5 years ago, I was Judicial Council staff, and the council did sort of track grant availability. A lot of it were, burn grants and federal government grants, and advise the courts if there were grant opportunities that were available that the courts could apply for. The Judicial Council would serve as sort of the repository of the grant requests, and because a lot of the times the funding would need to come in through a single state agency, and the Judicial Council would be responsible for the reporting on the grants, and so they would be providing proposals for some grant funding.
But were they out actively soliciting those grants, or was it provided to them through this other independent agency?
So they were searching for, they searched for grant opportunities.
Okay.
But yeah, often they were really based on sort of the organizational structure. These were often grant opportunities that really made sense for the superior courts to actually apply for to get the funding.
Mm-hmm.
I just, along these lines, the reason one of the funding sources for Utah was something called the State Justice Initiative, which is a source of funds for people running court systems. And I would think that there is somebody in California, sort of looking for ways to fund initiatives of various kinds that the courts are looking to do that they don't have room for in their budget of one kind or another. So I don't know, maybe that's something we can flag to figure out how to inquire further about, just really know. I mean, because Greg, to your point, if there's money available, it really kind of, eases the skids a little bit on everything else that needs to be thought through. And if there's not money available, then it seems like it's insurmountable. How are we ever going to do this when there's no clarity where the funds are going to come from? So.
Mhm. Yeah, and as Donna was discussing that, the way that which the funds are coming in to the judicial branch as well will probably influence the justice's thinking on this. I mean, there are instances in which the chief and, well, I know Justice Chin was on the Judicial Council for a while, have had to recuse themselves from litigation that has come to the court involving the Judicial Council. But it's going to depend on what the matter is and what's at issue. And so, that the more distance that the court can establish between itself and the funding source, the better, the easier it is going to be to, I think, find it to be a palatable option.
Good. Should we move on to the remaining options?
Sure.
Yeah, sure. I can take that over. So the next two options have to do with the entity or the regulator being housed within the state bar in some way. So the first one, option C, is what we have, which would be the operational support would be provided by the state bar, and the staff could be staff of the state bar, but there would be a separate leadership structure. We had a little bit of talk about whether that would be, you could have two boards within the same bar or not, if you had a board of trustees and then a parallel leadership entity, whether that be a board or not. But whatever the leadership entity would be, would directly report to the court. And so it wouldn't, and then the other option D, just so you can kind of see the two differences, we can talk about them together, would be, it would be more of an analogy of the Committee of Bar Examiners, I think, where there's a committee, they have their own, board, I guess, or Committee of Bar Examiners, but they still report, I believe, to the Board of Trustees as opposed to directly to the court. So that second option, that option D, would be, the Board of Trustees would still be kind of the ultimate decision maker, and then they would report to the court. So the pros for C, which would be just directly reporting to the court, you would still have these efficiencies because you would have, the existing operation of the bar, the overlap between, would be a little bit more consistent, hopefully, between, the regulation of attorneys as individuals and with the entities. It would be a government agency, so some of these transparency measures, rulemaking procedures are already in place, just kind of from the infrastructure standpoint. And then reporting directly to the trustees as a pro, to the court as a pro, would avoid this appearance of conflict of having, and other potential issues of having the attorneys on the Board of Trustees reviewing policies as it relates to what's happening with the regulator. The cons of this model, in addition to the funding model, which is something that I think is an issue for all of them really, would be potential antitrust concerns still, I think, depending on the makeup of whatever this leadership body would be. Also, because this is a really whole different ball of wax, I guess, when you're talking about the regulation of entities, and we really are trying to think about new ways of regulating, new ways of delivering legal services. It might be a little bit challenging for an existing, structure like the bar, who's used to operating one particular way and regulating one particular way, to adapt to a totally different model of regulation. So that could create some issues. So anyway, I think a lot of those are the same pros and cons for housing it within the bar. I guess like an additional con, if we were to have this entity reporting to the trustees as opposed to reporting directly to the court, would be this additional antitrust issue where you have a Board of Trustees that's dominated by attorneys, making decisions about, who can enter the marketplace. And I think it could just raise some additional concerns there. But those are really the two differences as opposed, the two potential options of having it housed within the bar itself. And so I thought I would just cover those two together. Does anyone have any questions about those, option C or D? Brady.
I was just, the antitrust is obviously very complex, but the bar's own governance has changed. There are no longer any members of the Board of Trustees who are elected by attorneys. It's all appointments. And it's now either a majority or half and half. Donna might be able to correct me, public members. So the concerns might be slightly reduced.
It's one more attorney than public member.
Okay, but they are all nominated by branches of government.
Yeah. But I'm hearing a lot of feedback. Is that just?
No, I'm hearing it too.
Okay. Oh, that's better now. Okay.
Could you repeat that? What is the composition of the Board of Trustees currently?
The composition is 7 attorneys and 6 non-attorneys.
Thank you.
And as Brady said, they're no longer they used to be elected by attorneys, which presented additional problems for antitrust, I would say, but that has changed now. So they are all appointed, but there is still a majority of attorneys on the board.
By whom are they appointed?
5 attorneys are appointed by the California Supreme Court. 2 are appointed by the legislature, one by the Senate Committee on Rules and the other by the Speaker of the Assembly. And 6 non-attorney members are appointed, 4 by the governor with confirmation by the Senate, 1 by the Senate Committee on Rules, and 1 by the Speaker of the Assembly.
Thank you.
And then Greg, is it by constitution that the authority to regulate the practice of law is sent to the state bar, or is that by a court action? Is that the Supreme Court delegating that?
Fundamentally, the regulation of the practice of law is inherently a judicial function. And that's I think every state in the United States has held that through case law. The state bar itself is a constitutional entity, public corporation. It sits in the California Constitution under the judicial clause, Article 6. And so it's always been a judicial function. The state bar itself was created by the legislature in 1928 to assist the court in its function in terms of admitting attorneys and disciplining attorneys. And so it's really an administrative arm of the court. The one thing I would say about these two options, because I guess I'm caught on reporting to the Board of Trustees, because essentially what we're trying to replicate here from the attorney model is who is going to be in charge of admitting participants and disciplining participants or exiting them. And ultimately, under the attorney model, that is still the court. Anyone who is not admitted to the practice of law, if they believe they've met the requirements and the state bar refuses, they have the right to petition the court to overturn that decision. And of course, when it comes to attorney discipline, if anyone's license is suspended or disbarred, it's a recommendation from the state bar court. The Board of Trustees is not involved in any of those decisions. And so the court really still retains ultimate authority in that regard. So I think option D, is it option D? I think we could probably take that off the table because it really doesn't reflect what structure is for attorney admissions and discipline.
And may I ask you, Greg, in our jurisdiction, once the bar has done its thing to do character and fitness investigations, bar exams, confirm that people are, indeed law school graduates and all that, they put together a list of who it is that they want to recommend to the court be admitted. But the order admitting those people to be lawyers in our state is an order of the court.
That is correct.
Is that such the same structure in California?
It is.
Yes.
Yeah.
Okay.
But can I ask you something with respect to that, Greg? I think what I'm trying to wrap my brain around here is what about the way that the Board of Trustees currently sets policies. So they may not make the decisions with respect to who's in and out, but they do have a role in policy making to a certain extent. I think the court still approves what they ultimately decide to do. But what do you think about that?
There are a set of rules that the State Bar Board of Trustees promulgates on their own. And then there's rules that require Supreme Court approval. And trying to sort that out is probably not easy to do, since I think State Bar rules are, there's State Bar rules of procedure, there's State Bar rules of practice. I mean, it's over the years it's developed and it's hard to track. But I think fundamentally what we can say is, I think any rule that has to do with those core functions of the court in terms of admission and discipline really do ultimately have to come to the court for approval.
And you can use as a parallel, I think it's, I'm going to get it wrong off the top of my head, but I think it's maybe Rule 9.4 of the Rules of Court, which expressly provides that certain rules related that come from the recommended rules that come from the Committee of Bar Examiners that are related to the admission to practice law, despite the fact that they are state bar rules, get sort of approved by the Board of Trustees, but ultimately submitted to the Supreme Court for adoption. So the Board of Trustees acts as an intermediary in that sense, ensuring that what the Committee of Bar Examiners is proposing is consistent with the direction that the board thinks is appropriate to set. But then the ultimate determiner on that, even though they are state bar rules, is the Supreme Court. And so you could certainly build a similar rule of court for rules that would relate to the practices of this sandbox.
Bridget, would you explain a little more when you write the words entity operated by the state bar? What is it you're sort of envisioning there? What does it mean to be operated by the state bar?
I think what I mean is just like it would be almost a separate office, but it's kind of within the infrastructure of the bar itself. So like there's an admissions office and there's the OCT, Office of Chief Trial Counsel, and then you have
Committee of Bar Examiners,
like a separate office that would be the regulator of the sandbox. Does that answer your question?
Bridget, let me provide a comparison maybe that will work. I'm thinking of the Client Security Fund. So we have an office of staff that comprise the Office of the Client Security Fund. They provide sort of the staff work largely that provides recommendations to the Client Security Fund Commission. The commission deciding whether or not we are going to reimburse clients for financial losses caused at the hands of their attorneys. In my head, when I see, C or D, that's sort of what I'm envisioning here, is that we would have an office of whatever we want to call it, that would have a governance commission that would be making decisions on the recommendation of staff who work in the office.
I mean, I think that's helpful. I suppose the question I'm still trying to, so now I'm an applicant and I'm submitting my application here. Am I interfacing with people who have a calbar.org email? or is it some sufficiently separate office that, maybe those people get a paycheck from CalBar because that's how the funding, the financial structure is set up. But I guess the question is simply how discrete of an office is it? Regardless of whether it reports to, well, even if it is reporting directly to the court, if it's essentially, where the employees and their HR are all being handled by the executive director of the bar. I don't know, that's I suppose that maybe that's too deep in the weeds, but I can see that kind of mattering, how that gets structured.
Yeah, I mean, I think there's pros and cons to that. I mean, what's pro is that there is HR there, I'm assuming, Donna. You know, there are, a lot, kind of back to the original idea there, the first idea that was talked about with the setting up a whole independent entity. That is a lot to have to think about, just starting a whole office from scratch and thinking about all those kinds of just infrastructural things that need to happen to have a new entity. Whereas you could take advantage of that either under, I don't know, like the Judicial Council, I guess, or something like that, if it were to be with the court or with the bar with their own infrastructure already in place. But I mean, I understand what you're saying. I kind of getting to one of the cons that I was trying to express too with this is like, this is different. It's different than what we've been doing before. It's different than the typical regulation of attorneys. And even just from an optics standpoint, from the applicants, like, do we want them to be associating existing bar structure with what we're trying to do? Aren't we trying to do something innovative and different?
I think that's an important point. I agree with the questions John is raising. If you look at the likelihood that innovators, people who are not lawyers, are going to feel like this is a welcoming body to which they're submitting their application, I just think that there's a practical risk that when they see the state bar, they think this is lawyers. Lawyers are the gatekeepers, and they won't bother applying. It will send a message to them that that lawyers will have their self-interest first. And I think there's also an issue about the confidence of the public in the objectivity of the decisions that the group would make for similar reasons.
Do you think that would be the same if it was within the court? Do you think people would have that same perspective?
I don't. I can see why. It's a good question. They might say, well, they're lawyers too. But I like the way Utah did it, because it depends on what the court sets up. If the court might set up something that's run by lawyers, that's under the auspices of the court, you'd still have the same problem there. But if you look at the way they've structured it in Utah, with the court in charge and with the composition of the body, the way they've structured it, I don't have that concern.
I suppose the question becomes, how do we find that out, Jim? How do we find out if that would really meaningfully impact innovators? It's tough to know. I mean, I guess we could inquire. We could ask our only non on the list here, which is Eric, if he's got any take on whether that, conceivably matters in the world of people who might interface with this regulator.
I mean, I think it depends on how sophisticated we think the people that are going to interface are, right? I mean, in some sense, if we change the name, if it was housed within the state bar for HR and IT purposes, and ultimately answered, but it was called something completely different, I imagine there are some people that sort of wouldn't notice that. There are others, who are investing a great deal of money who would do their due diligence and sort of have concerns. I guess the one other question just kind of related to that is, is there a way that this could take advantage of those, kind of the infrastructure of the bar and still be the nonprofit model, right? Because that does allow you to, I don't know that the state bar can receive grants, but at least initially there's a funding problem for this. And so, I did wonder if it was possible to just, essentially rent space from the bar for $1 or something that, for this to, take advantage of that. Because I do see what you're saying, right? That, if you think that it's not going, if the agency's been captured by, entities that have put a block on this to begin with, then yeah, I do think people would investigate that and have concerns.
What about lawyers who see this office for non-lawyers being operated by the bar and wonder what their dues are going for? I guess they could really have a concern that their money is being spent, in a way that isn't appropriate. You have to make it clear the funding is not coming from the lawyers somehow.
That concern was expressly raised when I was on ADLS and doing some focus groups. I heard that exact thing. Like, we don't want our, what is that going to do to attorney dues or their dues, their fees? So yes, I think that's the point. Eric, did you have something else to add to that?
Well, one thought was the board of the nonprofit, could it have, can members of the judiciary serve on that board? Because, one possibility is to create this nonprofit entity in which the board of that nonprofit is actually, members of the judiciary, which might be a way around the reluctance of the court to, if the court doesn't sort of want to take this on for the reasons Greg's mentioned, there might be members of the judiciary who are willing to serve in an oversight role over a nonprofit, which might be a way to bridge some of the pros and cons.
I think it's really hard when we're, the issue that we're kind of grappling around the nonprofit, which certainly seems the sort of hardest to envision of the models. While there are challenges with all of them, that one seems the kind of most out of the realm. I think primarily around the regulation piece. And for those of us, who are, very involved in the bar's regulation of attorneys and understand, the role of the Supreme Court, as, I was just reminded of, it's very hard to understand. I like the FINRA idea, Bridget, that might be something that's applicable, but that other than that, it seems like a real stretch. I mean, yes, you might have standard setting bodies and all. There's a lot of different standard setting bodies that are nonprofits in all different fields. But that's not exactly what, regulating in the sense that we're talking about, with accountability to the various stakeholders here. That seems like a real reach to me.
On the question about whether the bar receives grants, I know it does. I mean, I know it has, right, Donna, in the past. I don't know if that, what, can you give us an example of that?
I'm certain the answer is yes, we have in the past. I'm sorry, I'm unable to sort of pull one up top of mind right now.
Well, I was thinking of the Access Lex one comes to mind for me.
Oh, yeah, of course.
Yeah.
Yeah. So, right. So there was we've gotten grant funding from Access Lex to provide some admissions related services. We've requested grants for analysis from grants from Access Lex. So yeah, that's a great example. So that's certainly something that we've done.
And then from a conflict standpoint, and I think maybe what Greg was saying is like, as long as the court is kind of removed from that grant, I'm just wondering, like, would that alleviate your concerns, or knowing that if it's not the court itself that's receiving the grant, but like the bar that's receiving the grant, or whatever this entity may be that's receiving the grant, is that like far enough removed for the justices to feel comfortable with from a liability standpoint?
Well, I don't think that we could be concerned about liability, but I think,
conflict.
Yeah,
I mean,
from a conflict standpoint,
yeah.
Sure, I think it probably would, because it's the devil's always in the details.
I know.
Because we'd have to really define exactly what court oversight means under this model, and the level of involvement of the court in terms of supervising within the state bar. Obviously, once you bring this function within the court's walls, you're bringing the court closer to the process. And so I think that there's a higher level of sensitivity. If the funding organization is one that is unlikely to ever appear before the court, then I think there's a greater comfort level there. But if it's if it's a foundation based in California and they're involved in a lot of activities, I think that we just can't be in a situation where the entire court has to recuse itself.
Yeah, no, it's an important question.
Yeah. And I think judicial counsel, I'm interested in learning more about how, because I think some of the grants, it would be interesting to know what grants the state bar receives and for what function, because I think what Donna was referring to early on was when the state bar receives grants, and their role is really to administer the distribution of those funds to other ultimate recipients, which is a bit different. I think what we're talking about is receiving grants to actually pay for the administration of a regulatory function, which makes it a bit different.
Hypothetically speaking, and with lots of devils in the details analysis, the cleanest quote unquote model would be something under the Supreme Court where the funding comes from a government source. Because the conflict there in terms of the members of the court will be largely alleviated at that point. Now, we're not there yet. We may never get there, but just in terms of tying a lot of the threads of the conversations that we've had for the last 20 or 25 minutes. And again, we still have a fifth option to bring to your attention and discuss that checks the most boxes at this point.
And
How viable is it to get government funding, Dan, or any of you?
It's government the court gets funded by the legislature every year, and there's a precedent for that. Whether in the climate that we're in COVID, with severe budget dislocations that are going to get only worse before they get better, that's that we will need to explore very carefully. On the other hand, and again, I don't have, and I don't think anybody's in a position to have a bottom line answer. I don't anticipate that the amounts of funds that we're looking for in the context of California, there's a phrasing in government of it's called budget dust. This would be budget dust in the state of California. It's millions, but it's not. We're not looking for many hundreds of millions of dollars.
Sorry, Eric, I know you've had your hand up for a while.
Greg, just a quick question on this. It seems like the concern is if the funds go directly to the judiciary, that you may be in a situation where the entire court feels it has to recuse itself, which is what we want to avoid. So am I correct in saying in some ways we want only a subset? Because I could see the same thing going for fees, right? If you had a large bank that decided it wanted to sort of enter the market, you wouldn't want to be in a position where that bank had paid a fee to this entity, and then the entire Supreme Court has to sort of recuse itself. So what you're saying, I think, is we want a subset of the judiciary, because we have recusals all the time. Judges own stock, and they have to sort of recuse themselves. It's just we can't have the entire court in a position where it feels that it as an organization has a financial interest in a party that might appear before it. Am I getting this right? Again,
I don't think the payment of a regulatory fee in order to receive government service, in this case being a participant in the sandbox, would create the type of conflict that might force a recusal.
Okay.
I think that's different, and that's a point that I wanted to bring up. And this is, as we sort of model this a bit, it's going to be important to know what level of funding is necessary from outside sources. And I imagine, at least I had imagined, that the model that we were trying to move towards was that the office would be funded by the fees from participants moving forward, just like the state bar is essentially funded by attorney fees. And that's actually one concern that I would have. I mean, I think attorneys not only might be upset if their fee was going towards the funding of this other regulatory function within the state bar, but some may even say it constitutes a tax on them at a certain point, and there may be a challenge based on that.
Yeah, I think there would definitely be a challenge based on that.
Yeah.
So there would have to be very clear accounting for the funds to make sure that that mandatory fees that are paid by attorneys are not used for this program. There would have to be very, very strict accounting for those purposes.
And just back to the recusal issue, I don't want this to become such an obstacle that we take anything off the table. I just want to make everyone sensitive to this issue, because I think the justices will be. And as we start to really craft a model that might work as an option within the Judicial Council or the Supreme Court, that we just keep that in mind and perhaps think of ways to avoid that problem. So.
Mary, let me suggest something before we continue our discussion, just out of a sense of fairness and putting all the options in front of us. Can Bridget maybe finish the last option, and then we can pick up the conversation at that point?
Yes, Justice Tucker, though, I saw your hand is up. Do you want?
That's fine. Go ahead.
Okay. So the last one, just to make sure that we had all of, different options on the table, would be the executive branch option that Greg alluded to earlier. And sorry, I just lost there we go. One example of a place, although, just to try to conceptualize it, would be, we talked about the Department of Financial Protection and Innovation as an example. It's like a department under the executive branch where they are currently regulating, it used to be the Department of Corporations and then Business Oversight, and now it has a new name, but it's kind of the same thing. It's more like the financing, consumer financing kind of regulation. Or another example could be like the Department of Consumer Affairs, where all the other occupational licensing, most occupational licensing agencies are housed. The pros to that would be, that's what they do over there, like a DCA, for example. That's just what, they know how to do it. Maybe there's partial funding structure available just based on, the overhead that they already have at DCA or this Department of Financial Protection. But the cons, as Greg mentioned too, are, require a lot more research, but for sure there are some constitutional issues with respect to the separation of powers. It is hard to envision like how all three branches would really have to be involved in this. It seems kind of difficult from that standpoint. And also just even in the regulation of the legal industry, you would have, the bar under the court regulating lawyers, and then this entity under the executive branch. So there could be some inconsistencies there. So those were just the quick pros and cons that we put together, but we wanted, that is something, as I think my other memo from Adels, we talked about that, and I think we had raised it in this committee too. So we just at least wanted to put that on the table. Just Tucker, do you have your hand up still, or were you?
I haven't moved it. So whenever you're finished with
I'm
this
done. I'm done.
I'm ready to address.
That's a very quick overview, but I just wanted to, I think Dan was right. Just to have this on the table as we're having this discussion is important.
Well, I think the work that you all have done to lay out some options is awesome and is very helpful and moves the ball forward. My own view at this point is that because we're dealing with legal services, it seems like it should be under the Supreme Court rather than the executive branch. Because we're dealing with government regulation, it should be a government entity and not a private 501c3. And although I feel less strongly about this, I'm kind of inclined to think, because of the importance of keeping lines that separate what we're talking about from what lawyers pay into, what the public looks to as a regulator of lawyers, what applicants would look to as an entity dominated by lawyers, that there is an advantage to being separate from the state bar. But it was a little bit sort of subsumed in your option B under the Supreme Court, that we might look at an independent entity under the supervision of the Supreme Court. I think of it as sort of a little sister to the state bar, or take out the little, a sibling organization to the state bar, in the sense that, like the state bar, it would be, I don't know, do we call the state bar an independent entity? It would be an entity under the state bar that has an independent existence and has its own, not only its own staff, but its own board and its own decisions that are then all reviewed by the Supreme Court, but that we give the Supreme Court a certain ability to hold it at, to be a reviewing body rather than a deciding body, would be one way of putting it with regard to the decisions of this entity. And so I saw that you had separate entity in there in your description under option B. But I wonder whether there might be a fruitful avenue for developing how much separateness an entity could usefully have. And given the size and sophistication of our state legal market, would it perhaps be appropriate to have a little more separateness than exists in Utah? I'm not sure, but thinking of the state bar as one kind of entity under the Supreme Court and the Sandbox regulator in Utah as a somewhat different kind of regulating entity under the Supreme Court might give us two models that we could use as to triangulate and come up with our own sense of how we might develop a parallel organization.
That makes a lot. Actually, I don't know if we have that quite articulated as an option right now, right? Because I think what you're saying is it would be like another entity, just like the bar is another separate entity, but it wouldn't be under the bar. It would be its own thing, reporting to the court, just operating similarly as the bar does, but it wouldn't necessarily be a nonprofit, and it wouldn't be under the bar, and it wouldn't be like as part of the court. It would be its own governmental entity reporting to the court.
That's right. Like the bar, it would be legislatively chartered. It would be separately funded in the sense that it would be a separate line item. And it would be separately constituted in that it had its own board where you could have some people who were appointed by the legislature and many who were appointed by the court and so on. And it would make its own decisions, but its own decisions would all be reviewed by the Supreme Court. If the applicant didn't like the yes or the applicant didn't like the no, or the public didn't like the yes that the entity gave to an applicant.
Just like it would operate the way the bar does for attorney regulation, but this would be like the entity regulation.
Right.
Thank you. I had thought of that at one point and I forgot all about it. So thank you for saying that. Other comments about any of these? I think somebody had their hand up and now it's gone. I don't remember who it was now.
Yeah, I had my hand up, but then Justice Tucker so elegantly summarized sort of the critical parts of all of this that I'm not sure the point that I was going to is worth pursuing. I thought in terms of advancing the ball a little further, it sounds to me like the consensus might be that options E and D on our list really maybe could be put to the side, specifically the idea that it's a legislative entity or that it's an entity operated by the state bar with reports to the Board of Trustees. And that if Justice Tucker is stating the consensus, which I'm not saying she is just yet, that B, with that variation around the nature of the office, is maybe the lead candidate, but are A and C also still, in the conversation? I guess that just trying to distill where we are with the conversation. What do y'all think?
From my perspective, I agree that D and should, at least for now, be put aside for different reasons. But again, we may need to revisit. With respect to A, B, and C, we probably need to, and I think this is consistent with what the justice was saying, pick and choose some elements from each of them and see whether it's viable. Again, I think the critical issue where we will need to sort of figure out is the funding sources and what order of magnitude we're looking at. We can come up with the best model, but if we can't fund it in a way that's can do the job, that model will effectively not move us forward.
Well, if we're going down this road, and let's just go down this road for a moment, of something that's legislatively chartered, that means there's at least some sort of, I'll use the word pilot project, being set up via a legislative act for some discrete period of time. And I guess, could it have a fiscal note with it? Does that give us the ability to drive the funding also through the legislative process?
Broadly, yes.
Broadly, yeah.
We just need some of that dust that Daniel's
Yeah.
talking about.
And at some point, subject to some instructions from the justice, we will need some measure of needed funding, not nearly to the penny, not even to the millions, but are we looking at $5 million? Or are we looking at $15 million? Or are we looking, again, on some level, that could govern some of our options and thinking? But an order of magnitude of needed funding is something that I think we will need to focus on relatively soon.
You know, I do want to address something that I was looking in the Q&A, the comments from Stephanie, is it Stephanie? Yeah, Stephanie Bond has been asking about why couldn't this be a for-profit? And I mean, at least from my view, and everybody can weigh in, but to me, I think we're not saying that the applicants can't be for-profit or operate for-profit businesses, but we're talking about what the regulatory governance structure should be. And at least in my view, I don't think, I'm not sure how that would work, because we're talking about this as a regulatory function and a governmental function. But it's hard for me to understand how a for-profit anything could be also regulating and not have a conflict of interest here. So I don't see, I'm not aware of any governance models that are for-profit. I just wanted to make that clarification that we're not talking about the applicants, but we're talking about the regulator.
Yeah, that reminds me of the other point I was going to make. I think, and this goes back to something Greg said, I think it's critical that our messaging includes the idea that although the pilot might be something that requires some startup funding, if you will, that the longer term model needs to be that the regulated entities are funding the regulation if there's going to be any kind of a permanent environment, just like there is for lawyers. So that's where the profit comes in, right? Because if somebody's being allowed to provide legal services and generate a profit for themselves with it, well, then they should be able to fund the regulation and the oversight that's involved. It's just that in the early going, that's not a viable model. I don't think you could start charging applicants from the outset, $10,000 a pop to try their idea in your temporary sandbox.
John, can you remind us what the fee structure, if any, is in Utah? Is it true that the applicants don't actually have to pay a fee?
That's right. But that's again stated as in the trial, in this experiment for this brief period of time, we're going to find funding elsewhere. But it also says long-term, if there were any sort of permanent regulation of entities providing legal services, which are not lawyers, then they need to, the model needs to have funding for the regulation come from those being regulated, just like lawyers are.
Mm-hmm.
And I'll note while we're on it, we've decided 2 years isn't long enough. And in terms of budgeting, I would think, we need to be thinking about for California, more than 2 years. And we're going to be recommending to the court that they extend that by another 3 to 5 years, just to give you a sense. Because for innovations to really come to market, it just requires a longer opportunity than a couple of years allows.
John, just to be clear, so three additional years for the sandbox.
Right. Now, whether the court approves that or not, I don't know, but that would mean ultimately a 5 to 7 year long project as opposed to a 2 year long project.
Right. And since we will figure this out and find out in due course, but because of the state we live in and the complexity and the size and how big the marketplace is, hard to imagine that we will require less time in California, even if we do have benchmarks in Utah and in Arizona.
John, can I ask if you, as part of the recommendation to your court to extend it another 5 or 6 years, are you going to recommend that they charge a fee this point, or is it going to continue to be free for the next 5 to 6 years?
It's a good question, Greg. I don't know that we've come down on that, but I think I'd personally like to see us move towards exploring, some fee being collected. Maybe it's not fully funded by the regulated entities, but that we start to have some mechanism there to collect some revenue.
Mhm. Interesting.
So I think someone was saying, John, were you saying, and I don't know from a standpoint as far as what we can vote on here as opposed to what we send to the larger committee to vote on. I don't know if it makes sense for us to take things off the table now or not. And I'm genuinely asking, I really don't know like how this is working. I don't know if anyone does know how it works.
Let me ask a friendly amendment to your question, if I may.
Sure.
Is there a consensus, at least for now, that options D and E should be put aside? They may come back depending on as we move forward, but is there a consensus among the subcommittee members that at least for now D and E can put aside, and we will focus on the things that we've been discussing in the last, let's say, 10 or 15 minutes?
I'm good with that. I guess I just wonder, like, do we need to be getting input from the other committee members or not about that? That's my only question.
Yeah, we are a committee, right? A subcommittee, however you want to. We're a committee of the working group, and I don't think there's any clear direction in how we, form the committee to say that we have to bring everything back to the larger.
I'm sorry, what I was suggesting is that we do a version of this presentation to the committee as a whole and explain that our recommendation of the working committee or subcommittee is that for now, D&E get taken, if in fact that's what we all believe. Does that clarify?
Yeah, I think that's a good idea.
And may I suggest that as you plan how to move towards the April 9th meeting, you work to flesh out what looks most promising and to minimize what looks least promising. So if in fact the subcommittee thinks D and E are both bad ideas, you don't have to give them equal treatment before the committee on the whole, because there'll be enough for the committee on the whole to focus on if you just present 2 or 3 options with all the many issues that are inherent in those.
Agreed. And we can also give a 3-minute presentation of other options that we looked at and decided that they're not promising at this point.
Can we take it one
Add one.
step? Can we take it one step further along the lines of Justice Tucker's summary and sort of organize these towards what seems to be, the most promising candidate, and maybe that's a little different order than what we have here, or do we need to sort of stick with this A, B, and C that as it is? Because I guess personally, and I think I'm thinking my friend Mr. Sandman might agree that the idea of having this under the auspices of the court with whatever the structure is that needs to be there maybe is a stronger candidate at this point than the independent 501c3, for example. So do we order that and sort of contextualize that for the group or not?
We can rejigger this working document. It seems to me that we can also add a section before we go into the 5 options or the 3 options that sort of highlights the concepts that the justice so well articulated as here's what we're looking for and the reasons for that.
I like my friend John's suggestion. If we can, I think we should avoid suggesting that we're indifferent among the options that we're leaving on the table. I agree with everything that Justice Tucker said earlier. And if we have a consensus among this group, I'd like to do something to try to list in order of preference or merit our assessment of the quality of the options we're putting before the larger group.
So I guess to that end, I mean, Justice Tucker has suggested a rationale for favoring option B. Does anyone disagree that that's our number one candidate?
Well, I understood Justice Tucker to be offering something that's really not on our list, right? On either A, B, or C, right? Isn't it a different number altogether? A different letter? Is that F or is that the new D?
I'm not trying to answer that question because I think that, well, let me just answer it this way. Your option B includes some phrase about possibly a separate entity. So I'm really trying to build on and grab that phrase and say, what about
I see
that out as a fully formed option? So maybe the options then become a fully formed entity under the Supreme Court parallel to the state bar, or a less than fully formed and independent and legislatively chartered and funded entity under the Supreme Court, perhaps more like Utah, or right in the state bar, or completely independent 501c3, something like that.
Mm-hmm.
Yeah, that's perfectly put from my perspective. I did not take the justice's comments as being yet another option. I think it's a sub option that's PO'd. But we can flesh it out based on the discussion that we had.
Mm-hmm. Okay.
So getting back to that, does anyone doubt that that's our sort of number one on our list? Sounds like we're in violent agreement.
But I would ask for our group of observers here. Does anybody see a huge, completely insurmountable barrier to that option that we need to be sure we haven't, addressed a bit before we go that way with the entire committee? Randy, I'm looking to you. Donna, is there something that we're missing here that we just really need to give some thought to further before we go that route?
When you're talking about the formation of a completely separately chartered entity, I think that does raise the ante in terms of the cooperation between the California branches in terms of the regulation. And so I know, for example, the legislature has its own set of provisions for creating any new state licensee program, but we're not looking to adopt the legislature's approach to creating licensed persons in the state of California, but they do exercise some authority over that. And when you're asking to create and the state bar is a public corporation, it's not a 501c3. And so if it is a public corporation, that's a different animal altogether. So to me, it does raise the need to fully manage the cooperative relationship of the legislative, executive, and judicial branch in the creation of what is, I guess, a parallel to the state bar.
Thanks. Yeah.
So there's one other point that I don't think has to stand in the way of an entity that's parallel to but separate from the state bar, but I think we need to be aware of and intend to address. And that is, and this is something Randy and I discussed, so he can correct me if I get some of the specifics wrong, but I think that the California Constitution says that anyone licensed to practice law in the state of California must be a member of the state bar. And there's an attorney general's opinion that Randy pointed me toward that suggests that, well, that doesn't necessarily mean that an entity given permission to do something that is the practice of state law has to be licensed by the state bar. But it's at least something we want to make sure we're aware of, and that when we do some legal analysis to explain why our entity makes sense and how our entity works, that we address that. Which brings me back to a comment that one of you made in saying, I think maybe this was Daniel, that getting some pro bono legal assistance from experts in this area, in the area of entity formation, to make sure we get our legal our legal authority and our details right might be useful. Randy, you and I also discussed getting pro bono assistance for this group. And I know we have Brady on the line. Is that something that either the subcommittee or the committee as a whole could commission for assistance in thinking through thoroughly and carefully some of the issues?
When Closing Just the Gap Working Group was actually formed, there was contemplated the formation of advisory bodies that would be authorized for the chair to create. And so the example at the time was for having consumer groups, because we couldn't have the full range of actual consumer legal services input. We wanted to be able to pitch the proposals of this group to, say, a consumer focus group formed by the working group. But I think you can also use that as a mechanism for getting other types of advisory input. When it comes to receiving what I would call actual legal advice, that's where I think the Office of General Counsel has purview. And so if we're getting expert input on technical matters that wouldn't necessarily constitute legal advice, I think you can create advisory groups to facilitate that. If you're actually seeking legal advice, I think we need to go through the Office of General Counsel.
We would not be able to draw on the expertise of outside law firms in their area of specialty to get advice, to get legal advice? Why?
Well, the Office of General Counsel provides legal advice to the State Bar, and that's their function.
And I would just think we would want to let the Office of General Counsel sort of direct the right. It's not that we couldn't necessarily get sort of pro bono legal advice from others, Dan, who are expert in those areas, but I think we would want to have the Office of General Counsel sort of direct the sort of securing of that advice, and help identify people that may be in a position to provide us that legal advice. So I think it would just be a matter of working through our Office of General Counsel to identify those resources.
Okay, I guess my own personal view is that I certainly don't have any problem working with offices of general counsel. I think any number of us, Jim and I and many others, have been to any number of lawyers and law firms who are likely to be in a position to help, and would like to at least have some input as to who should be reached out to in terms of choices to be made. I mean, it seems to me at the end of the day, the decision as to who the committee wants to get assistance from is up to the committee.
Certainly, but also, at the end of the day, the board wants to have full confidence in the recommendations that are coming from the committee. So I think a partnership, which is all I'm talking about, between the committee and the Office of General Counsel, and figuring out sort of the appropriate steps for seeking legal advice would be an appropriate way to go.
So it seems we're already close to having an issue that we would like to get some legal advice and assistance on. Perhaps it's not too soon to begin figuring out the process of identifying who we might go to and what we might ask them to do. Would it be appropriate to ask members of this subcommittee to talk perhaps offline with Brady, unless you tell us, Donna, there's a different way to do it, about who we would encourage the Office of General Counsel to reach out to, or whether we perhaps Daniel has somebody in mind he thinks would be great. Would there be any reason that he couldn't reach out to that person and test whether that person was interested, and then bring a recommendation to the Office of General Counsel that the subcommittee consider reaching out to that person?
Yeah, so I think the best thing to do would be to make sure we clearly capture what the sort of the legal request is. Right, so what is the legal research, the specific legal research that we're looking for? And then, you know, we can loop in the Office of General Counsel to get sort of a sense from them of their in-house expertise on this issue, and get, you know, names from recommendations from the committee, if we don't have the in-house expertise on this, get recommendations from committee members on people that they've already spoken with, who might be available, or people that they are aware of. And, you know, as part of that, please let us know if we can name drop. And so I think sending that information through Randy, or Andrew, Randy or Andrew, you tell me which one, would be the right way to go.
That's
So
good.
Send it through to me and I will work with Brady.
So just to be clear, I don't have a specific law firm in mind, but the organizations like APCO, who represent over 200 of the finest law firms in the country, these are the pro bono partners and coordinators for these law firms. There's a new alliance, the Law Firm Alliance Against Racism. That's not the exact name, but it's something like that, that has over 300 law firms. They're been advertising throughout the country for the availability to help on a pro bono basis for things of that nature. Again, I think everybody on this committee probably has some contacts with at least one or two members. So reaching out to the leadership of either one of these organizations, there's great overlap between them, seems to me one of the ways to reach into this deep wealth of knowledge that would be in a position to help us.
Well, I guess I would just say, I think what we're circling around here in terms of what we need advice on is pretty complex questions of entity formation and the relationship between the different branches of governments. And I think that expertise is pretty narrow. And I think I can think of a couple of law firms that are probably, you know, have that expertise. I think it's going to be a kind of political law with some corporate law expertise. So I would imagine, I'm not sure that there's going to be a huge pool of people who have this particular expertise that I think we're talking about.
Let me suggest the following moving forward step. Why don't the two co-chairs of SAGE, the justice as a leader of the entire organization, and maybe Bridget and myself, formulate what it is that we're looking for in terms of legal assistance, and then circulate it to everybody for them to fine tune. And then we can work with the Office of the General Counsel and anybody else who we need to go forward. The one thing I would caution is that we don't yet know what we don't know. And it needs to be, there needs to be some flexibility in terms of going down some path that we haven't in these early stages even began to explore.
Can I suggest, Dan, although I'm happy to help and be involved in all of that, that you consider a request for legal assistance to be part of the report you will make to the Committee of the Whole on April 9th. And so
Great idea.
Use your existing committee structure, and I'm happy to be involved however it's helpful. As you further develop what you want to report to the committee, I know one of the questions on your agenda is what further steps do we need? And I think maybe an answer to that is we would like to ask a law firm to answer the following question on the following timeline. And then the Committee on the Whole can take that request up on April 9th.
Done.
It's a great idea.
But Dan, I think the idea that we get together and formulate what that specific request is, its scope, and you know what we don't know also needs to be determined is a good step related to that.
Okay.
So just to try to move this along, and I think I think we're all agreed that B, this B variation is number one. Then if we want to rank the rest, are we all agreed that D is a no-go? And are we also agreed that A stays on the list?
I think A stays on the list. I think D and E at this point, are being put aside. We may need to come back to them because we have to, because there are no options, because of legal hurdles that we don't know about. But for now, we're not gonna do additional work on them, subject to being able to do so down the line.
So where does that leave us on C?
I think that stays on the list, but I don't hear a lot of enthusiasm for that option.
Yeah, I think that's right. The only observation I make about that is is there not a structure where this freestanding or separate entity could somehow contract for certain IT or HR services from the bar, so that the efficiency issues related to the bar can still be gained without the complications that we've talked about.
Let me suggest the following approach. Why don't we have B as at this point, with all the disclaimers, a preferred approach, and then list other options potentially still in play as A and C, and options that we're taking off the table now, D and E. It seems to me that it's not all that productive right now to spend a lot of time yanking between A and C, because we simply don't have enough information to be able to do so, in my view, in a meaningful way.
I agree with that. I just think I'm saying probably some of the pros and cons discussion in those on options A and C, will inform us a little bit about, maybe there's some features of some of those that play into where we ultimately come down.
And we will work it out. But Bridget, my view, at least right now, is that we're going to keep the pros and cons of both A and C, explaining why they're still potentially in play.
Can I just ask real quick to John's point, you have the California Bar Foundation. Is that still with you, or did that go to California Lawyers Association? By you, I mean the bar, Donna or Randy. And if so, do they rent services from you, or how does that work?
I think that's part of Change Lawyers.
Yeah. Oh yeah. Isn't that what it's called now?
Yeah, I think it's California Change Lawyers.
Yeah.
And so no, so there's no sort of overlap in services. The best example of an overlap in services was the transition of the trade associational part of the bar to the California Lawyers Association. When the California Lawyers Association first opened its doors, it was more of a theoretical opening of the doors than a physical opening of the doors. And so the staff remained housed at the state bar, supported by state bar IT, et cetera. And they were, we were basically, renting the space that the staff were using to the California Lawyers Association. The California Lawyers Association were paying the equivalent of the salaries and benefits for the staff that we were essentially contracting the staff over to California Lawyers Association. So that would be sort of that model. That was a temporary issue, but we were largely, I think, contracting the staff that were doing sort of the trade associational function. I don't recall the extent to which there was a portion of funding for IT staff and for HR staff and for all of the support services that are provided from general counsel and others. And that would certainly need to be part of the equation if we were to do it this way, which, would require, potentially additional state bar staffing in order to be able to support that.
One more thing I'll mention about the former State Bar Foundation is that many years ago, when the state bar's funding was vetoed by a governor and the bar was dark for about a year, funding for certain professional competence regulatory activities were actually acquired through grants. I think they were passed through the foundation. And so we didn't want to have a lapse in the update to the California Compendium. And Harry Sondheim, the then chair of COPRAC, was able to work to get grants through the State Bar Foundation to actually fund the State Bar's production of the update to the compendium. So I'm not exactly sure how they pulled that off, but it is an example of grant funding for what is essentially a regulatory activity.
So just in with an eye to the fact that we have about 12 minutes left, I think, why don't we just see if we agree on next steps? So I think obviously one next step is to reorder our memo and flesh it out a little bit. So and Bridget and Daniel, I think you have some ideas about that, and we can talk more. Secondly, I think as part of that, we want to flesh out option B a little bit more along the lines, clearly there's a sort of variant that or at least parts of this are being further discussed, a little bit different than as presently stated in the memo. So we want to do that. Third, we want to formulate what our possible requests for legal advice are, formulation of what the problem is that think we might want some help on. Is there anything else that people can identify as next steps?
And can I just jump in on that last one and say that to the extent we can identify before the meeting what the ask is and have the State Bar have an opportunity, through Randy and then Brady to tell us whether or not they agree that's something that's appropriate for outside assistance, and to the extent we can find outside assistance, to take the pulse of someone who we think might be a good service provider in what I agree, Mary, is a very specialized area at the confluence of public and corporate law. That all would lead to an even more precise and well-informed recommendation. We would like to be able to ask X entity to answer Y question before our next meeting, for example.
I think we can certainly try to formulate that aspect, or we'll see how far, but I agree that would be great to push it to that point. Any other steps that people can think of that would be productive for us to take in advance of the working group meeting, or even from the working group meeting forward to try to move this along?
This is Brady. I think the Justice's suggestion is fantastic as far as, to the extent possible, getting our feedback before the April 9th meeting. I would caution everybody in discussing this amongst yourselves to remember Bagley-Keene, and it might be necessary to have discussions through Randy. Certainly, if you're going to be polling the entire committee, you shouldn't be doing that. You should, send your ideas to Randy, and then staff can reach out to the whole committee and collect the information, because we shouldn't have a majority of this committee discussing anything outside of the meetings.
But we can have, for example, 4 of us discussing an issue. For example, if the small group of John, me, Bridget, and Daniel wanted to try to sit down and build out this formulation for legal advice, that would be fine, wouldn't it?
I believe so. What is the total number, Lauren, of this committee?
Well, we had a resignation.
Oh, we did.
Sorry, it is 7 with the resignation. So 4 would be a majority.
Right. So we should try and keep it to 3 people, sort of the task force working on this, and then if they want to get more feedback, that can be handled through a one-way communication by staff.
Maybe we can get another person on our committee.
I hear that request.
We'll be working on that, but
thank you, Lauren.
Probably not in time.
Got it. Understood. And thank you. I'm glad we clarified this. Thank you.
And Dan and I can we can get together and at least flesh this out based on this conversation and send it to Randy and go from there.
Mary and everyone, this has been a really, really valuable, constructive approach, and I'd like to thank Dan and Bridget for taking the lead. And I guess the question I have related to this in our few minutes left is we were also going to attempt to deal with the details of the governing board. And I'm wondering if there's a way, to advance that by memo in some way before the April 9 meeting. I don't sense there's near as much pros and cons there. There's really more fleshing that out, and maybe, I don't know that we're going to get consensus around that such that we can present it April 9, but does anybody have any thoughts on how we can advance that aspect of this? Or does that just need to be tabled until this other issue is matured a bit more?
I think that when we discussed it at the last working group meeting, we had the ADL's recommendations, which were fairly specific, about categories of persons to be on the board. And I don't think that it's so abstract at this point, and certainly until we understand the scope, it's a little bit hard to be identifying specific people or categories of people that might be useful. That would be my sense. I don't know if others disagree.
Yeah, any other thoughts on that? So does that mean, Mary, that we just sort of table it and it'll come together when it comes together, because we generally have a lot of the text and the thinking done from ADLs?
Yeah, I would say that, maybe one way to frame it perhaps, and maybe this could be in what we present on April 9th, is that consistent with our prior discussions, our preliminary recommendation is basically to adopt the ADL's recommendations subject to further, amendment and refinement as we move forward. It just seems funny to be thinking in very specific terms about who's going to be on something when we don't know what it's going to do or even how it's going to be structured.
I agree with that. I think that makes sense for right now, especially since we did have a pretty detailed recommendation from ADLs on it, at least for a starting point discussion.
Yeah, I certainly support that. Is there anyone that sees that differently, would like to have that just sort of left aside, or are folks comfortable that we generally advance the idea that at least in broad terms, we're going to recommend following the approach just laid out in ADLs?
I would do it softly. So generally, yes, but again, I think the board at the end of the day is a function of what we want to build, and we don't know yet what we are building. So generally, absolutely, but there may be both practical, legal, and maybe even political reasons to deviate down the line. So as a concept, absolutely, let's just keep it a bit soft.
Good. Yeah, and at some level, we may even just want to say just that, Dan, that because we may just want to include that element of it in our report.
I apologize, but I'm gonna have to jump off. I have another presentation I have to give at 3, so I have to run. But anyway, I'll work on this and I'll catch up if I miss anything in the last 4 minutes. Sorry about this.
Well, thanks a lot, Bridget.
Thanks. Bye-bye.
So do we have anything else that people want to discuss? Any other business we need to? I think this was really productive. Thank you for everybody for participating, and especially to Bridget and Daniel.
Thank you.
Anything else? All right, well, why don't we adjourn?
Bye-bye, everybody.
Thanks, everyone.
Thanks, everyone.
Thank you, everyone.
Bye.
Bye.